the chair thanks Mr. Whitehouse. And now the chair will begin the round of questioning by recognizing himself for 5 minutes for the purposes of questioning the witnesses. And I just want to ask the witnesses if we need to go into a second round of questions. The chair is willing to do that if the witnesses can make themselves available for an additional round of questioning from the members of the subcommittee. The chair recognizes himself for 5 minutes. Exclusion payment settlements are unique to the pharmaceutical industry. In all other industries, as I stated in my opening statement, patent disputes are settled in two ways. One, the accused infringer pays a royalty to the patent holder, or two, the two parties agree to an early entry date. It is my belief, and has been stated earlier, that only in the pharmaceutical industry do we see the very unusual behavior of a patent holder, which the brand name drug company, suing the accused infringer, the generic company, and then paying the accused infringer to stay off the market. Only in the pharmaceutical industry. I want to ask Commissioner Rush, do these types of settlements happen in any other sector? And while you're answering that, think about this question. Why are these settlements unique to the drug industry, and what keeps them from occurring in other industries or commercial sectors? And how does the framework of Hatch-Waxman impede or enhances this kind of activity? Those are the questions that I have for you.
Chairman, let me take them up one by one. First of all, yes, I do believe that these kinds of settlements, that is to say, the kinds of settlements with which this legislation is concerned, are unique to the pharmaceutical industry. I think I take issue with characterizing them as payment settlements. They are not that. They are reverse payment settlements. They are settlements in which the holder of the patent actually pays the person who is alleging infringement some money or other thing of value. We do not, frankly, see that kind of settlement in any other industry. So that's the answer to the first question. Second, why don't we see it in any other industry? It is not because we consider either the branded or the generics to be nefarious. It is simply a matter of economics. Now, what am I talking about in terms of economics? First, state substitution laws, as well as various kinds of formularies, very much encourage switching to a lower cost drug from a branded drug that is under patent. Second, because of that encouragement, generic drugs are inclined and incentivized to switch their drugs as quickly as possible. And to do that, they are willing to actually take a haircut on their prices, well below that the brand charges, because the brand is able to charge monopoly prices. Third, that threatens, however, the brand tremendously, because the brand's drug is still under patent, and it is able to avail itself of monopoly pricing, brand monopoly pricing, as well as brand monopoly profits. Fourth, because it is so threatened, the brand is willing and incentivized to go ahead and share some of those profits with the generic. And that is what happens when it offers a reverse payment. It is, in fact, sharing some of those profits with the generic. So finally, The reverse payment settlement is a win-win proposition for both the brand and the generic. It helps the brand, on the one hand, maintain its patent monopoly. And secondly, however, what it does is to incentivize the generic to abandon its challenge to the patent monopoly and therefore to eschew the kind of pro-consumer activity that the Hatch-Waxman Act was originally designed to encourage. There is nothing wrong with the original Hatch-Waxman Act. To the contrary, its incentives were perfectly aligned. It gave the brand something, it gave the generic something for challenging the brands. The problem is not with the Act. The problem is with the court decisions which have ignored the teaching of the Supreme Court as well as what the framers of the Act had in mind in enacting the Act to begin with.
The chairman's time is ended, and now the chair recognizes my friend from Florida, Mr. Stearns, for 5 minutes for the purposes.
Thank you, Mr. Chairman. I ask unanimous consent that the letter that was sent to you and Mr. Radonovich, the academic study that draws a reference that Mr. Whitehouse mentioned, draws out the complexity of determining whether reverse payment settlements are anti-consumer and demonstrates that these settlements are actually pro-consumer, in most cases, being made part of the record.
Hearing no objections, so ordered.
This is an interesting hearing, Mr. Chairman. You have the pharmaceutical industry, and as I understand it, the generic drug industry is aligned together. It's the most unlikely alliance here. Mr. Whitehead and others I represent, I mean, as I understand it from my staff, Dr. Sherman, you're alone here, that most of the generics, isn't that true, Dr. Sherman, that most of the generics are not supporting this bill? Is that true, Mr. Whitehead? Most of the generic companies are not supporting this bill?
That is correct.
Okay, and then the pharmaceuticals, obviously, Ms. Berry, do not support it. So I say to Mr. Rush, you have here the pharmaceuticals against the bill, the generics against the bill. In this case, you've pointed out pretty in detail how the courts have ruled that the Hatch-Waxman bill is working and that these reverse payments that you use, you don't like my term, the settlement payment, that they actually are acceptable legal remedy and they're not anti-competitive. Isn't that true, Mr. Rush?
Some of the courts have done that.
No, but in general, didn't all the courts show that these agreements are not anti-competitive?
No, that is not correct. The Sixth Circuit in the Cardism case held that they were, in fact, per se illegal. The 11th Circuit and the Second Circuit, however, have held otherwise as a matter of policy. And as I said before, I think it's Congress's authority to make policy.
Did you say the Supreme Court wouldn't even rule on this because it was decided by the lower courts?
No, the Supreme Court did not rule on it because, as you know, the Supreme Court doesn't review all circuit court decisions.
Well, wouldn't you say the majority of courts have ruled that this is not anti-competitive?
2 to 1, you're correct.
2 to 1, okay. So we established 2 to 1 the courts. So what this bill is trying to do is circumvent the courts, and where the courts have heard legal arguments on both sides, and a 2 to 1 majority have said that this reverse payment that you use, which I say is a settlement payment, is not anti-competitive. Is that a true statement?
No, it is not correct. First of all, because the Supreme Court has held in other contexts, that is to say when they're not part of a settlement, that exactly.
But not in this context.
No, the Supreme Court has not addressed this.
That's what I'm saying. Okay.
State.
You know, I think when you look at the statistics that before the Hatch-Waxman, only 19% of the generic industry share of the prescription drug benefit was only 19%. After the Hatch-Waxman, it went up to 70%. So that would show that it's working. I hear no evidence that if we pass this bill that you're going to go from 70% to 80 to 90%. In fact, you might go lower. And Mr. Whitehead, if this bill passed, the statistics that I just gave you before the Hatch-Waxman went to 70%, do you think the statistics will go lower if this bill's passed?
We believe it's documented in this economic study that the very real risk that there will be disincentive to the generic companies.
So why would we want to do harm then when with something that the court says is not anti-competitive? We've got both people involved have indicated they don't want it to happen, and we've got a study to say the overwhelming statistic that it's going up to 70% is working, and we have a study that says, in fact, if you pass this bill, the consumers will have less choice, and so it's a little interesting to me. And I have Mr. Rush, here's a question for you.
Thank you.
When you have statistics where it says that the study claims that in all patent litigation initiated between 1992 and 2000, the generics prevailed in 73% of the challenged drug products. But I don't think that's telling the whole story. How many of these wins resulted in actual generic products coming on the market?
Well, let's assume that it's 45%, as you...
No, let's just take 73% as the
Okay.
statistics that's used. Of that 73%, how many of those resulted in actual products being put on?
I can't...
You know why? I can tell you it's probably low, because if a product consists of color, shape, compound, and dissolution, and they might win 3 of the cases. They say, okay, we won on color, shape, and dissolution, dissipation, let's say, but the actual content of that, the compound itself, they lose on, they can't do anything.
Well, let's assume it's 45%, as you suggested earlier.
Okay.
Let's assume it's 45%. That means that in 45% of the cases, these reverse payments are actually operating to hurt consumers. Under those circumstances, even if it's
No,
one
but
case-
ultimately, with the reverse payment, settlement payment, my terms, with that means the generic drug finally comes on. Otherwise, it would be, I think you mentioned it, 80 years, or somebody in the panel said it would take 80 years of litigation. So you suddenly have this litigation abruptly stop. You have in 6 months the possibility of generic coming on the market, and this whole litigation process ends.
Well, there's nothing in the bill that would chill settlements at all. There were lots of settlements that were made before the court ruled in Shearing. There have been a number of
Okay,
settlements
I just want to say,
recently.
there's no evidence reverse settlements have actually reduced costs.
The chair now recognizes Mr. Stupak for 7 minutes for the purposes of questioning the witnesses.
Thank you, Mr. Chairman. Dr. Sherman, let me ask you this question. In June of 2008, Pfizer reached a settlement with Ranbaxy concerning Lipitor, the world's top-selling drug. According to press reports, the settlement delayed the entry of generic here in the United States until November of 2011, up to 20 months later than many analysts had been anticipating. The settlement of litigation here in the United States was part of a global settlement in which Pfizer granted licenses to Ranbaxy, authorizing Ranbaxy to sell generic Lipitor in 7 other pharmaceutical markets: Australia, Canada, Belgium, Germany, Italy, the Netherlands, and Sweden. The deal is reported to allow Ranbaxy to sell generic in those 7 countries 2 to 4 months earlier than the patents expire. It was also reported that the deal would make generic Lipitor available in Canada earlier than in the U.S. Pfizer also dropped its challenge to Ranbaxy's current sale of generic Lipitor in 4 countries: Brunei, Malaysia, Peru, and Vietnam. Both Pfizer and Ranbaxy said the agreement did not involve any payments. It seems to me that this global deal was full of payments. Under the settlement, market entry for Lipitor appears to have been permitted earlier in a host of countries than here in the United States, which coincidentally happens to be the largest market in the world. So I have 3 questions, if I may. If we pass legislation solely banning reverse payments, will we see more arrangements like this where delayed entry in the United States is tied to settlement of litigation permitting earlier access to generic in markets outside the United States? Secondly, won't companies attempt to evade the payment ban by taking the position that settlements outside the United States are not subject to U.S. requirement that settlements reported to the Federal Trade Commission? And third, if the Federal Trade Commission prosecutes them for any such effort, won't the length of time it takes to do so be so long that any opportunity for savings from generic competition really be lost? I ask you to turn on your mic, please.
Sorry. My concern is not only that reverse payments are not the fundamental problem, it's the ability to block other generics by reason of keeping the exclusivity. That's the fundamental problem. But there's no question, in my mind, that no matter how one tries to stop reverse payments by legislation, not only is it even if it worked, it wouldn't have a significant effect, but it can't work because the creative minds of thieves are without limit. And there's no question that deals can be simultaneously done outside of the United States, and Lipitor is not the only example. For example, venlafaxine, Effexor XR is another example. Some years ago, Teva settled with Wyeth and agreed to a very late entry in the United States, and at the same time they settled a Canadian litigation that allowed them on the market in Canada through their Nova Farm division. So Canadian consumers have had low-cost generic Effexor XR for years, where it's delayed in the United States under 2 agreements that were entered simultaneously, one outside of the United States. And that probably is beyond the purview of the American courts, because the American courts don't have jurisdiction over foreign companies operating abroad, and there's no way to stop simultaneous signature of agreements that appear to be unrelated or that can be said to be unrelated. Also, attempts to block anti-competitive agreements by the FTC taking action will be futile because they'll become moot by the time it's decided. It may be decided after 5 years after an agreement is signed that it's improper, but in the meantime there's no other generic firm, because that agreement is there, able to justify investing to challenge the patent or bring the product to market. So even if a challenge were to an agreement were to work, it would be moot by the time it happened. So the concern that we have is not only that attempts to block anti-competitive deals by banning reverse payments won't be effective, but it's not really addressing the fundamental problem, and that is not the payment itself, but the fact that these deals whereby the subsequent entrants, subsequent filers who would fight, can't fight because they can't get on the market, that's the problem that has to be addressed. Give shared exclusivity to a subsequent filer who wins. That solves the whole problem. The problem disappears and consumers will get the benefit.
Well, let me ask this one. I'm going to ask Professor Hemphill if he could answer this one. H.R. 1706 only prohibits a very specific type of provision, exclusive payments, in drug patent settlements. That is, the bill only prohibits the brand name drug from paying or providing value to the generic company in exchange for the generic company delaying market entry. The bill does not ban legal settlements in general. History has shown us that drug companies are perfectly capable of settling their patent disputes without exclusion payments. When the Federal Trade Commission and states cracked down on these types of settlements in 2000, they disappeared, and drug companies settled their cases just like any other companies do in other industries. However, when the courts then invalidated the FTC's enforcement efforts in 2005, exclusion payment settlements came back with a vengeance. So, Professor, doesn't this show that drug companies are perfectly capable of settling their patent disputes like any other company? And is there any evidence from the settlements from 2000 to 2005, which did not contain reverse payments, were they any more costly or difficult to achieve than settlements with reverse payments?
So that's a terrific question. It's difficult to get to the very bottom of the question using publicly available information, though based on the work that I've done as to settlements, with respect to the information that's in the public domain, the answer does seem to be yes. That is, just as you've suggested, drug companies during that interregnum when the FTC rules seemed to be in effect did seem able to settle, just not able to settle in an anti-competitive manner.
Right. Okay. Commissioner Rausch, did you find the settlements during this period to be more costly or more difficult to achieve by drug companies during that 2000-2005 period when your enforcement mechanism was there? Okay. Anyone else care to comment on that? Ms. Berry, did your companies find it more difficult or more costly to sell when we did not have that 5-year period of time?
Thank you, Congressman. I would just say that I think Mr. Hemphill is right that the publicly available data aren't sufficient to show that for a fact, and I would.
How about your internal data on behalf of pharma? You must track that, do you not?
No, we do not track the number of settlements each year.
Okay.
The gentleman's time has ended.
Thank you, Mr. Chairman.
The chair now recognizes the gentleman from Nebraska, Mr. Terry, for 5 minutes.
Thank you, Mr. Chairman. I'm one of the I think, maybe 2 or 3 trial attorneys on this side of the aisle. Omaha, you're right. But wow, I knew there was something I liked about you. And settled hundreds of cases, wrote, read settlement agreements. But I got to tell you, this one's a little out of the box for me, so I'm going to have to kind of take some small steps and ask you some generic questions, pun intended. That's as good as it gets up here, folks. So, Mr. Rush, just so I understand the scope of things, how many, just taking the last 5 years, how many of these reverse settlements have occurred? Are we 5, 10, 500?
At least 103 that I know about, Congressman. Our staff reviewed that many at least, including, I should add, reverse payment settlements in which there were side deals plus a date certain for entry. So they were not always just payments of money, but there were 103 of them, and our staff found that all but a couple of them were very suspect.
Now, I'm sorry, out of the 103, or you found that 103 of them were suspect?
No, 2 of them were not suspect.
Were not. So 101 of them fell into
Were.
a category of being suspect.
And I guess that's why I have some problems with Teva's thesis, because they would like to exempt a lot of side agreements.
Okay. Now, as I understand, when they file their patent, when the brand name files their patent, I mean, there's a date certain there of when that patent ceases to exist and a generic can come in. I mean, that's very easy to find that information, right?
Yes, but.
Okay, what's the but?
The but is that there's also provision in the statute that for a certain period of time after the brand is entered, it will basically get a free pass. Normally that's 5 years, but it can go up to 7 years in the case of some pediatric drugs where there are relatively few sales. In addition to that, they get something that you and I never saw in our lifetimes as litigators, and that is that they get a certain period of stay time with respect to an automatic, if you will, preliminary injunction. And there's nothing like that
How long
in any other patent.
would that
law.
stay time average?
I believe
And who gives that stay time? That's not statutory.
it's statutory.
That's statutory.
That is
So statutorily, they get an extra amount of time because
30,
of
it's 30 months.
30 months. So I guess, is there then not clarity on when the date that the patent runs out, that the generic can just jump into the market without legal issue?
No. Again, this is a matter of the statute. The statute allows what is called the first filer, who goes
Right.
to the FDA first and certifies that it is not infringing or that the patent is invalid. And
Well, that's where, can I interrupt there? Because that's where part of my confusion is coming in. If the date for the patent has run out, why do they have to declare or somehow adjudicate that there's something wrong with the patent?
because the statute contemplates that before the patent runs out, the generic will be incentivized to challenge patents which are not valid or infringed, or in which validity or infringement is questioned.
Well, even though they may be incentive, they still have to find something wrong with the patent,
Correct.
unless they want to wait until the end of the patent date. So it seems to me that if they're incentivized to attack the validity of the patent because we want to have a policy that gets those generics out there sooner than the end date,
Yes.
I don't sure if I would agree with the premise that these are reverse payments. Out of the 103 then, let me just jump to my conclusion for my last, oh, I'm out of time, but
Surely.
let me ask this question. How many out of the 101 nefarious reverse settlements actually made the date that the generic got to the market sooner than the clear date that the name brand patent ran out?
The answer is, I believe, in almost all of those cases, it was sooner, but I would suggest most respectfully that that is not the question. Brand names do not pay tens or hundreds of millions of dollars in reverse payments to generics in order to accelerate their entry into the market. They don't do that. What instead they are doing is they're paying to keep that, to skew, if you will, the incentives of the generic to prevent the generic from actually challenging a patent that should be challenged. So that is the pernicious part. There's nothing wrong, I want to emphasize that, there's nothing wrong with the incentives created by Hatch-Waxman. The problem is created by the reverse payment settlement.
The chair now recognizes the gentlelady from Illinois, Ms. Schakowsky, for 5 minutes.
Let me just say that over 30 years ago, I was involved in, because I was a director of a senior citizen organization working to get the state of Illinois to pass generic drug legislation in the hopes that it would reduce the costs, which has proven to be true. My colleague and friend, Mr. Stearns, was talking about how incredible it was that the generic drug, or at least the first filers anyway, and the pharmaceutical companies were on the same side. Obviously, the problem is that they are, because both are benefiting to the detriment, it seems, of the consumers. Mr. Whitehouse, you were proudly citing the study, and you certainly didn't mean to imply that because Laura Tyson was an author that the Obama administration is supporting this point of view, did you?
Not at all.
Okay.
And
who paid for this? And who paid for this study?
My understanding is that funding was provided by Ms. Bierry's association, Pharma.
Pharma.
But they make clear that they express their independent views.
I just think that's important to note for the record, that the study that's being cited was paid for by the pharmaceutical industry. Dr. Sherman, well, actually, let me ask the Commissioner Roche. Is it Roche? I'm sorry.
That's perfectly fine.
What is it really, though?
Rush.
Okay, Rush.
Like the chairman's.
No, you should accept your real name. Okay, Rush. The suggestions made by Dr. Sherman, he proposed that maybe we would consider 2 amendments to the legislation. Do you or Mr. Hempel, if you want to comment on that, think that would improve the legislation, and why?
Well, again, I'm just speaking for myself, Congresswoman, but I am very reluctant to reduce the 180-day exclusivity period, or to water it down at all, or to dilute it at all, because I think that is the carrot. That's the incentive for the generic to challenge.
Okay, but if the first filer makes a deal, and then the second filer, well, maybe you can explain it better, Dr.
That's why I don't want, that's why I want to ban reverse payments, because that... Period.
Okay. But why is your suggestion preferable than Dr. Sherman?
Because we're not suggesting that the 180 days be reduced. We're suggesting that it go to or be shared by the person who actually earns it, the one who actually carries the challenge and succeeds in invalidating the patent. Right now, the first filer can settle and keeps the 180 exclusivity, which is a huge reward for doing nothing, for agreeing not to challenge a patent, and for agreeing with the brand company to defer generic entry until just before patent expiry at enormous cost to the consumer. They're not earning it. So we're saying in a case where a first filer has settled, it's not entitled to that exclusivity, but let them keep it anyway. Let's just give a shared exclusivity to the person who then picks up the challenge, does what Congress intended, invests in challenging the patent, and succeeds. If you don't do that, there's no incentive for anybody to pick up the challenge and to get early entry into the market in the face of a settlement by a first filer who's agreed to undermine the system and accept very
Okay,
late entry.
Mr. Hempel, does that make any sense?
So the underlying policy concern is a real one, that a first filer could settle, retain the exclusivity, and that would create public policy problems. Perhaps a simpler solution, a solution actually suggested by Apotex 2 years ago, would be that upon settlement, the exclusivity is simply forfeited. My concern about adding a new layer of exclusivity, in addition to the possibility of diluting existing incentives, is this is an extremely complicated scheme as it is. A lot of the problems result from manipulation of the 180 days. Doubling the set of possible or multiplying the set of possible holders of exclusivity, I think promises some confusion and complexity. The forfeiture alternative, which Apotex in the past suggested in response to the same policy concerns, strikes me as a simpler and maybe easier to implement alternative.
May I answer that? We did propose that 2 years ago, and it certainly would be better than what we have now, simply a forfeiture of exclusivity. But the problem there is then there is no incentive for a subsequent filer to take up the advantage, to take up the battle, and that is the very thing that the whole regime is intended to incentivize. So giving a shared exclusivity to a subsequent filer who does take up the battle is better, because then you're going to have someone investing to do it, and that will result in earlier entry into the market for generics. It's very important.
I appreciate this back and forth. Thank you.
The chair now will recognize the ranking member of the subcommittee, Mr. Radonovich, for 5 minutes for opening round questions.
Thank you so much, Mr. Chairman, and I beg the forgiveness of the committee. I had a prior constituent water issue that needed to be addressed. I'm a little bit late to this hearing. So, but I want to thank the panel for being here. I do have a couple of quick questions. First of all, to the Honorable Mr. Rush. Ms. Handy testified that H.R. 1706 creates 2 safe harbors. The first, that the only value allowed for a generic is the right to market a drug prior to patent expiration. Second, the generic cannot be sued for infringement, thereby insulating them, from any damages. A settlement is usually an agreement where both parties receive consideration. However, it seems that the considerations are entirely one-sided. What would be the benefit to the brand company to settle in this situation, number one? Number two, why would a brand company ever choose not to prosecute their patent to the fullest to see litigation through to the bitter end?
Well, with respect to the first issue, I think it really goes to whether or not side agreements should be or are covered by this legislation. And the answer is, as I indicated earlier, based on our own studies internally, side agreements can indeed end up being a part of the problem. So that's the answer to the first part of the question. The answer to the second part of the question really goes to the extent to which you want to incentivize, it seems to me, you want to incentivize the generic to actually challenge what may be an invalid or a patent that is not being infringed. And again, my view is that you want to give my own personal view is you want to give the generic the broadest possible incentive in that regard, which is what I think you do with the 180 days.
Thank you very much. Ms. Beery, is it? Ms. Beery? Thank you. Why is it so important for innovative pharmaceutical companies to retain the ability to settle patent litigation with generic companies?
Thank you, Congressman. Litigation is risky and expensive, and it incurs significant costs for both the brand companies and the generic companies. Companies have to have a way to resolve their disputes without taking them the whole way to trial. And so for both parties to this litigation, it's important to have the flexibility to be able to come to mutual arrangements that are still within the scope of the patent and therefore beneficial to consumers, and ultimately which will bring these medicines, generic medicines, to the market before the patent expires, but still be a fair arrangement for both parties to the settlement.
Wouldn't it be better, wouldn't the brand companies be better off if they successfully defended their patents in court?
That would be true if, in fact, the outcome of litigation were always certain. But litigation is risky, expensive, and uncertain, and businesses like certainty, as you well know. So it's often better for the brand company to, within the scope of its patent, have a date certain by which it knows that the generic will come on the market.
I see, yeah. Question for the panel, anybody who cares to respond. Our government and our American companies engage in daily fights against intellectual property theft. It seems, however, that a number of our witnesses are arguing for less stringent IP protections when it comes to pharmaceuticals. I think that we could all agree that life-saving innovation must be encouraged, but it seems, however, that you're arguing that the IP rights of some innovators are less worthy of protection afforded by the law than perhaps Hollywood or Silicon Valley or Nashville. Many can defensively disagree, but I'd like to hear any of your thoughts on the issues of intellectual property in general. Mr. Hemphill?
Yeah, I guess just to start, I think it's not true at all that the proposed bill here runs any risk of treating pharmaceutical companies, brand or generic, as second-class citizens. As matters stand, we have a very complicated regime that's already very different from what anybody else gets. Commissioner Roche mentioned a few moments ago the special 30-month stay granted to a brand name firm, even if the patent is extremely trivial. Patent term extension, of course, is another example. There are examples on the other side, but to think of this as an example of second-class citizenship for pharma companies, I think is far from the fact here.
All right. Anybody else care to comment? Mr. Sherman? Doctor?
But what distinguishes pharmaceuticals from other industries is this unique provision whereby the first filer has exclusivity to block others. So what you have when you have under this regime, a brand company and the first filer negotiating, the parties that are not at the table are the public and the other generic firms who would be prepared to continue to fight. And the settlement, to which they're not a party, affects them because it precludes the other generics from fighting to win because they're blocked by the continuing exclusivity. And the consumers aren't at the table, and they're the ones who are paying the billions of dollars of extra money as a result of the settlement. So, sure, this bill would treat pharmaceuticals differently because it would ban reverse payments. But the question that should be asked is, why are they happening in this industry? And it's happening because the present regime permits a first filer to settle on behalf of all of the generic industries and consumers who are not at the table. So the way to fix it is not to have special provisions that bar reverse payments, but to fix the regime so that a first filer who settles is settling only for himself and is not blocking another generic who would in fact continue to invest and fight for earlier entry.
Gentleman's
Thank
time
you.
is concluded.
Thank you, Mr. Chairman.
The chair now recognizes the gentleman from Louisiana, Mr. Scalise, for 5 minutes.
Thank you, Mr. Chairman. First question, just open up to the whole panel. If you can explain or give an example of a case where Congress has actually specified that a certain industry-specific private settlement would be illegal. Start with Mr. Whitehouse and work down.
We're certainly not aware of any, and we think, in fact, it is important to recognize, and these economic papers do point out, make the important point, that this isn't unique to pharma, that every settlement in any litigation, as any litigator will tell you, involves some mutuality of consideration or there wouldn't be a deal. And so it is the technicality of how the money or the compensation moves in any particular transaction. It's an artifact, but it's not in the end of any interest, because a settlement is not going to happen unless both sides are getting something out of it.
Thanks. Mr. Sherman?
Well, again, the problem is that this industry is unique because the first filer in this case who settles is settling on behalf of everybody and entering an agreement which blocks all others from getting to market. That is what distinguishes this industry, and that is what is wrong. That is what should be fixed.
Do you know of any other cases in other industries where this type of proposal that's brought forward is?
No, because there's no other industry where somebody gets an exclusivity by reason of doing a challenge and can block all others. That is the problem.
Not sure that that's the case, but Ms. Beery?
Congressman, I'm not aware of any other industry in which a bill targets settlements of a particular type. I would say that the courts, when they look at these, and to some extent the agencies, have approached these as a case-by-case, on a case-by-case basis, so that they start from the proposition that settlements are pro-competitive if, in fact, they would allow the generic to enter prior to the expiration of the patent. And if, in fact, they don't, then they may be anti-competitive. So they pursue a case-by-case analysis, which to us is more sensible than a per se ban.
Ms. Handy?
Respectfully, Congressman, I don't know the answer, but I think whether or not it occurs, the issue is whether it is good for consumers.
And then we'll get into that later in the question. Thanks, Mr. Hippel.
Yep. The litigation, the settlements, and the proposed fix are all industry-specific and unusual.
Unusual. Thank you. Mr. Rush?
That is correct.
All right. Well, thank you.
But
First round. Well, let me ask Mr.
As
Rush
has been
then,
pointed out, however, Congressman, this industry is very unusual as well.
I'm sure, and many are in their own rights, many industries. According to your reports on settlements, there have been over 50 settlements filed with the FTC in the last 3 years. Your testimony, I think, said a large number of them have side agreements, yet of those 50, the FTC has not filed legal challenges against any of them, and private plaintiffs have brought suits against only 2 of them. Why has the FTC not challenged any of those settlements?
It's quite simple, Congressman. We're trying to pick those settlements which we think are most pernicious and we think we can win. We want to win one of these cases because we feel that we're not only the guardians of consumers in this fight, but also the guardians of you folks who enacted Hatch-Waxman.
So I guess that means you don't feel you could have won the other ones that have been filed.
No, I don't mean to leave that impression. What I do mean to leave is the impression that the ones that we've challenged, we think are the ones that are most obviously pernicious to consumers and most violent.
But obviously you make a calculated decision then if you don't, you only bring a suit if you feel that you can win.
No, that's not necessarily so.
That's
I mean,
what
if
you
we
just
had
said.
unlimited resources, we'd probably be challenging all of them, but we don't.
Well, the same's the case with the generic company that brings a case to court as well. They don't have unlimited resources either, but obviously they feel they've got merit, and that's why they bring the case, and then this bill would remove their ability to settle. Several settlements, including those involving Prozac and tamoxifen, have saved consumers and taxpayers billions of dollars. Looking back, do you believe such settlements were anti-competitive merely because they contained some type of settlement, or reverse payment, as you call it?
Do I think that tamoxifen and
well, do you feel that those settlements were anti-competitive? They were legal. They would be illegal under this bill, yet they did save consumers billions of dollars. So how do you justify trying to take away that ability to save consumers billions of dollars, as has been the case in past settlements?
We certainly thought tamoxifen was a bad settlement, that we thought that was an anti-competitive settlement, and we saw nothing, no data whatever, that would suggest to us that it saved consumers billions of dollars.
Mr. Whitehouse, I know I'm running out of time. Experts have testified that collateral agreement side business deals like these licenses are co-promotion agreements on products unrelated to the patented product in dispute can help the litigants in a patent suit bridge the gap and reach a settlement on patent litigation. Have you experienced that? You've taken some of these cases before.
Yes, absolutely. That is crucial to the point that we've made in our testimony, is that the ability to reach these settlements and bring these products to market sooner in cases that we must not forget we could have lost. I mean, everybody sort of assumes that we didn't settle, we would have won. It is very important to remember that something else we could have lost, and the consumers have been denied any benefit until the expiration of the patent. And so the opportunity to come up with these alternative or additional terms that enable the parties to bridge their different perceptions of the case, bring about a settlement that, on average and typically, will bring these products to market sooner for the benefit of consumers.
I see I'm out of time. I yield back.
Chair now recognizes Dr. Gingrey for 5 minutes.
Mr. Chairman, thank you very much, and direct my question to Commissioner Ross. Commissioner Ross, I think you've been very forthright in your response to the questions throughout the hearing. Having said that, I guess you are anticipating that I'm fixing to blast you.
Yeah.
Not really,
I
but
call it piling on.
Yeah.
But that's fine.
But in a number of ways, I do find your testimony to be counterintuitive. You say that the reverse payment settlements negatively impact consumers by delaying entry of generic drugs to the market. Based on the testimony of the other witnesses, many times these reverse payment settlements, they actually allow the patent holding company and the generic company to negotiate terms by which the generic can begin being marketed before the expiration of the patent. Presumably, because of the unique nature of patent law in this area, the settlements actually help consumers, it would seem to me. But then, what then is anti-competitive or anti-consumer about this kind of settlement? And before you respond to that, a quick second. I think it was Mr. Radonovich that was asking you about the question about side deals, and you may have talked about other consideration in a settlement, not including reverse payments. But my concern,
payment of dollars, you're correct.
Yeah, but this bill, as I understand it, would prohibit any of that, not just dollar payments, reverse payments, but any other side deal. So if this bill passed, then what incentive would the brand name company have to settle? Certainly, it would appear none whatsoever to negotiate with the generic. So, two questions, and go ahead.
Okay. I think you're correct about the bill. As I read it, it would indeed go to side deals as well as to direct payments of money. As I said before, that doesn't really trouble me because our staff has taken a look at these agreements, including side deals, and they have concluded that except in a very small number of instances, those side deals are anti-consumer and they are anti-competitive. And incidentally, Congressman, there's nothing at all unique about banning this kind of deal within the context of a settlement. The United States Supreme Court said that an anti-competitive aspect of a settlement agreement could be struck down as per se illegal many, many years ago in the Singer case. So this is not brand new. But let me get to the sort of the first part of your question. Why, I ask myself, if indeed the effect of a reverse payment settlement would be to stifle entry, early entry, to delay early entry, why are these deals occurring? And we are seeing them. Why is the brand willing to pay, as I say, millions of dollars in these settlements? And I would suggest to you that the reason is to delay entry because the brand is enjoying patent monopoly profits and prices. It's kind of as simple as that. Now, should we be litigating these cases on a case-by-case basis? I would suggest to you that we should not. There is already in the bill sort of a safety net, if you will, in our rulemaking authority. If we find that some of these deals that we shouldn't be challenging them on a case-by-case basis, we can carve those out as a safe harbor.
Commissioner, reclaim my time, and I'm down to 45 seconds because this is kind of a segue. No, I appreciate your response. Segue into my question that I wanted to ask Ms. Beery and Mr. Whitehouse. As representatives of pharma and the generic drug companies, respectively, you know through practical implementation that both the FTC and the Department of Justice already have the ability to challenge any settlements that, and I think that's what the Commissioner was about to say, that are anti-competitive and thus harm consumers. If the blanket ban on settlements in H.R. 1706 is implemented, what incentive do your respective industries have to settle patent litigation out of court, and how would that affect consumers?
Thank you. I'll begin by saying that I think because litigation is risky and expensive, I think there would still be incentives for companies to try to settle patent litigation, even if H.R. 1706 were to pass. Unfortunately, the options for them to do so are what would be very limited. And so you would be left in a situation where the brand and the generic company would be only able to negotiate over the date of entry for the generic. This is the heart of the patent dispute, and obviously the parties are going to have very different views on that point. And so in many of these cases, we think that they would be unable to reach an agreement, and the case would then have to proceed through litigation. And recent statistics show that in most of those cases, at least the majority, the brand company would ultimately be able to defend its patents, and so generic entry would be delayed.
And if Mr. Whitehouse, Mr. Chairman, if you bear with me, if Mr. Whitehouse can respond to that question as well.
Yes, Congressman. And the important point to focus upon here is that if you make it harder to settle, you're going to reduce the incentive to bring these cases in the first place. And if the whole point of Hatch-Waxman was to precipitate litigation over doubtful patents and bring generic products to market sooner, if you discourage, if you diminish in any way the incentive in the generic companies to initiate those litigations, which is an inevitable consequence of making it harder to settle them, that is inherently anti-consumer and undesirable, and that's why we're opposed to this mechanism.
The chair initially offered that we will go into a second round of questioning, but there is a vote on the floor, and in light of this fact, then the chair will call this subcommittee hearing to an adjournment. But before he does that, he wants to make sure that the witnesses recognize the fact that we are indebted to you so deeply because of the investment of your time into this matter. You have really shed some tremendous light on this issue, and we will be referring to your statements, both pro and con, for the duration of this legislative process on this particular matter. I just want to also alert you that we ask that you should be prepared to receive and respond to written questions submitted by members of the subcommittee. And I want to, for the records, to remain open for 10 days to receive additional statements. And the final matter is that the ranking member of the subcommittee, Mr. Radonovich, has an opening statement that he wants placed into the record, and with hearing no objection, is so ordered. This subcommittee is now adjourned. Thank you very much.
Thanks, Bonnie.
Thank you, Mr. Chairman.